Well, hey, folks, in today's sentencing hearing, Donna Adelson delivered a dramatic, emotional statement asserting her innocence in that 2014 murder of her son in law, Dan Markel. Now, let's break down what she said in contrast to what the state proved at trial. Then, we'll see how the judge responds to her performance. Well, thanks, everybody. Welcome to Profiling Evil. Hit that like and subscribe button. I just got off of a plane from 2 weeks in Eastern Europe. You know, this case has been layered with grief, betrayal, family intrigue. Years of investigation, multiple trials, and shifting narratives have built us to this moment, Donna Adelson's sentencing. In the legal theater of high-stakes murder cases, an alocution is often an opportunity for the defendant to shape narrative before a judge imposes sentencing. And what you say and how you say it can matter. But when emotional language overshadows substance, the judge might see it all as a performance rather than penance. Now, here are my thoughts on the hearing today and what Donna Adelson presented, how it measures against what the state proved, and how the court responds. Personally, I found it really offensive that Adelson began by praising Dan Markel, saying what a fine and decent man he is, a caring and loving father. All true, but coming from her, it sounded a little shallow. She recounted the entire sequence of July 18th, 2014, his car being followed, the last time he'd see his children, the fact that he was brutally murdered. She emphasized the loss, stating his children only have pictures and memories. And she repeatedly invoked her broken heart, the ongoing trauma for the boys, saying, "My heart's broken." But keep in mind as you watch it in a minute, there were no tears. And then she started shifting the blame by contesting the state's theory. She pointed out that over the years, the state labeled several masterminds in the case, and she re-insisted that she had no knowledge nor any plan to kill Dan Markel before the murder, saying, "Hey, if I'd have been aware, I would have stopped it." She challenged the state's evidence and connected all of it, saying it just wasn't her. She also attacked the prosecution's money drop theory and argued that the defense's motion for a change of venue was rejected, despite their proof, in her opinion, of widespread public negative publicity. Now, she claimed juror bias also, and she lamented that one juror, in her opinion, admitted having background knowledge about the case before the trial. She decried her conviction as a miscarriage of justice, claiming, "Hey, again, I'm an innocent woman, a grandmother," saying convicting me would not be retribution for Danny's death. And then she reaffirmed her innocence emphatically, saying, "I was not involved. I swear to you on my life, I was not." But you know, it didn't end there. There was no sorrow, no regret in this allocution. She told the court that she intended on filing an appeal and pushing for a fair trial outside of Tallahassee. She contrasted her personal record with her fate, saying, "Look, I've never even gotten a parking ticket, and now you're sending me to prison for the rest of my life?" Again, without any tears. Now, the judge, in my opinion, didn't seem impressed, as she repeatedly argued where was the evidence, and the court warned her that it might take into consideration her utter lack of remorse that she was displaying, clarifying to the defense that the court's not barred from considering the tone, the blame shifting, or the lack of remorse when imposing a sentence. And man, make sure you don't forget what was proven in her trial. The jury found Donna Adelson guilty of first-degree murder, conspiracy to commit murder, and the solicitation in the 2014 killing of Dan Markel. They convinced the jury that Adelson helped orchestrate this murder-for-hire plot, that she had the motive, the financial means, and the family influence to orchestrate or facilitate the plot. Her communications, her financial transfers, suspicious behavior were all presented as circumstantial support, and a jury found her guilty and convicted her. In short, the state presented a narrative tying motive, co-conspirators, and circumstantial evidence all together. It wasn't a smoking gun confession, but in the constellation, it persuaded the jury beyond a reasonable doubt. So I want to take a moment and let you listen to her statement to the court. And please, watch her face closely as she tries to cry, but nothing comes out. She dries her eyes, but there are no tears. Let's watch.
Thank you for letting me speak. My son-in-law, Dan Markel, was a fine and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." But pictures and memories are all they have because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine Magbanaw's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue,
that
Mrs. Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
Where is the evidence before July?
You certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop, to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." Not one person, not one, said, "I think she may be innocent." That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances which are properly given to the appellate court. What does any of this have to do with sentencing?
Could I have just one moment, please?
Please.
What happened to Danny is unforgivable, but I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with any of it. There are 2 crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for Danny's death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a fair trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, as I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way with Danny's murder. I was not.
Going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocuted without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misconduct of others. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Very well.
Well, to me, one of the most striking elements of Donna Adelson's allocution was the emotional language. The repeated appeals to loss and heartbreak, and the palpable sense of anguish in her voice. She was describing the violence, the terror of seeing a gun, the lifelong grief of two young boys who are going to live without their father, Dan Markel. All powerful, rhetorical pieces. Yet, even as she spoke through her verbal sobbing, she never actually shed tears, at least not visibly. I mean, I could see her wipe her eyes with a tissue. That detail was telling because she was portraying deep sorrow, but the tears didn't come. There's a discrepancy between expressed emotion and psychological response that creates a sense of dissonance in this thing. So from a rhetorical or psychological standpoint, I think it matters. In a courtroom, tears can be taken as a sign of genuine remorse, maybe vulnerability or contrition, but without visible tears, the emotional display may risk being perceived as controlled, rehearsed, or performative, especially by a judge that's already on alert for theatrics. Now, it's possible that she deliberately held back tears or that the moment wasn't overwhelming enough to break her composure. But in a high-stakes allocution with cameras and scrutiny dialed in on her, the absence might leave an impression of staged emotion rather than spontaneous grief. And personally, I don't think the judge was buying what she was selling. Now, early on, when she began re-arguing the issue of venue and bias and prosecutorial strategy, the court asked her if all of that was appropriate, and the judge signaled to the trial record that they were more appropriately addressed on appeal, not in this allocution. And the judge specifically told her that the court was going to take into consideration, or could take into consideration, the utter lack of remorse that she was displaying. Now, that line was crucial in my opinion, because it's not the fact that the judge was listening to what she was saying, but the fact that he was listening to what she wasn't saying, and that might have weighed against her credibility and her demeanor. And the judge, when the defense argued he couldn't think about all that, read from a precedent indicating that a defendant can maintain innocence when speaking, but they cannot expect sentencing to ignore statements that shift blame, deny responsibility, or suggest lack of remorse. He said the trial court is not barred from considering those factors in imposing sentence. His tone was frustration, if not for contempt, for the stage theatrics that were going on. And by telling her multiple times that her statements were veering into relitigation, he warned her over and over again that the lack of remorse is credible to a sentencing decision. And the judge subtly but strongly signaled skepticism in her performance. In essence, the judge was saying, hey, you're free to speak, but I'm also free to interpret your words and your demeanor. Now, this is not a soap opera. Sentencing is not about a pantomime or emotion. It's about accountability. And he was reminding Adelson that her failure to show contrition would factor in. And at the end of the day, Donna Adelson's plea, in my opinion, was a classic innocence defense, emotional, personal, confident in her own character, but it directly conflicted with the state's narrative and the evidence that was portrayed at the trial. In zero-sum worlds of criminal allocution, the emotional weight of a speech has to align with credibility, and frankly, demeanor matters. The judge frequently considers the defendant's demeanor, their remorse, their willingness to accept responsibility. And I think the absence of tears, in contrast to the rhetorical mourning, might actually weigh against Adelson in the judge's mind. Now, Adelson's allocution was heavy on blame, blaming the jury, the venue decision, the jurors, the prosecution, and the state. And that approach was a gamble, in my opinion, because if you shift too much blame, the judge might see it as denial rather than contrition, especially in a case of this magnitude. So let's close this video with the judge's decision and the sentencing.
Having reviewed the cases presented by the defense concerning the downward departure, also as well the argument that has been presented, the court has reviewed its notes of the trial and will rule on the issue of the downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within Section 921.0026, subsection 2, subsection B. In reviewing the trial court's notes, what has been argued by both the defense and also as well the court's relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity. And these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub a Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
Well, there you have it. Count 1, first-degree murder, life in prison without the possibility of parole or release. Count 2, conspiracy to commit murder, 30 years to life, consecutive with count 1. Count 3, 30 years concurrent to count 2, but consecutive to count 1. Now, listen, folks, I'd like your comments down below, and I hope you'll watch for Profiling Evil on Facebook, Instagram, YouTube, and Twitter. And if you like audio podcasts, make sure you're checking out Profiling Evil's audio podcasts on your favorite podcast platform. Hey, thanks for your support of Profiling Evil. Watch tomorrow for my video at 3 p.m. Mountain on Dracula and true crime live. We'll see you soon at the next crime scene.